Our show it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, and welcome to the show. Today, our topic is strategies in litigating real estate disputes. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like and subscribe to the channel. We'd appreciate it. You can find us on YouTube, Facebook, and X. You can go to all of those, subscribe. Also, we have an audio version of the podcast. You can download that on Spotify, on Apple Podcasts, or any other podcasting platforms. Make sure to go download it. We would appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is discussing a new partition law that was passed here in Arizona by our legislature and goes into effect in September. And basically, the new partition law or act deals with property that's inherited. So to kind of start with the basics, and we're going to probably talk about this a little bit even on today's show. We'll probably have a larger show on the Arizona specific portions, but getting down to the basics, a partition action is an action that's brought by one property owner to force the division of property or the sale of property, and then the division of the proceeds from the sale. So when you talk about partition, if you have vacant land and, you know, the zoning and other laws allow for it, you can basically, if you have two owners and one owner doesn't want to own property in common anymore with the other owner, they can go and say, hey, look, court, let's divide this land, give the one co-owner the east half, give me the west half. They divide it in half, and that's a partition. But when you have a house on the property, you can't really divide the house in half. And so in that case, you do a partition by sale, in which the court goes and appoints certain professionals to sell the property and then takes the proceeds and divvies them out according. And there's certain things that can be disputed or litigated with respect to who gets what from the proceeds. But nevertheless, the proceeds are then divided out generally based upon the percentage of ownership of each owner with respect to the property. Well, changes have been made to our petition laws now to deal with the circumstance of inherited property. So this is where you have joint owners of the property, not as a result of going in and buying it together, but as the result of, you know, a family member passing away and devising or giving that real property to their family members or to their heirs. And that's how the joint owners have come into ownership and possession of the property. And this new law is going to impact real estate investors. And the reason is because there's a strategy out there, not only a strategy, but an opportunity, I guess is the better term, an opportunity for real estate investors on inherited property to, you know, provide basically in some ways a service, because what we found happens a lot of times is that the property, let's say it gets inherited by 4 siblings. There's always that one sibling who doesn't want to sell. And it's normally that same sibling that was living in the property rent-free with mom and dad, you know, before they passed away. they pass away and they continue to live in the property rent free. They view it as their property, even though they only own a quarter of it now. They don't want to sell, but they expect the other siblings to pay their share of the mortgage and the utilities and everything else associated with the property. And, to repair and maintain the property. But they're more than happy to live there rent free. And of course, the other siblings like, we don't want to deal with this. Like, no, we want to sell it and get our money out. But not many, and we're talking about this litigation, right? Not many people want to sue their siblings. It just isn't something that is good, right? They just are like, I don't want to sue my sibling. Like, I don't want to file a lawsuit and, seek to kick my sibling out of the house and sell the property. So what happens is, investors, they seek out somebody who's willing to buy their interest. And, when you buy an interest like that, you are buying it for less than fair market value because number one, you can't get title insurance for it. And number two, you now are buying a problem. And the problem is the sibling that doesn't want to sell and the sibling that's, residing in the property. And then, so you as the investor have to deal with it. And so, ultimately they get a really, a significantly below fair market value opportunity to buy out the other sibling's interest. They take title and before this law, they go and they file an action to force the sell the property. And then the court does its thing and sells the property and hands out the proceeds according to the ownership interest. And there was no legal mechanism for the sibling that did not want to sell to retain the family home. And because of that, our legislature has stepped in and passed this new law, which now has a lengthy process for inherited property in partitions, whereby an appraisal has to be obtained and objections can be made to that appraisal. Once the fair market value of the property is determined, the sibling who wants to keep the property has the right to buy out. And then there's a time frame and process for them to elect to do that or not elect to do it. But it significantly lengthens and creates red tape, a lot of red tape for partition actions of inherited property. So as an investor, be aware that if you are going to, have an opportunity to buy out a, percentage of ownership in property that's been inherited, just know that it's not going to be a quick process, that there's going to be additional costs, that it's going to be, lengthy, and there's going to be more red tape involved in working through the initial processes and procedures before finally the court will appoint somebody to sell that property. So just be aware that that's just a real rough overview. In a month or two, I believe we're going to have a guest on who's going to break this down in more detail, and we'll have a whole show on it where we're going to go through it step by step of what needs to be done. But I'm just putting it out there as far as the just general overview that we do have this new law, that if you're an investor, you have an opportunity to buy a percentage of ownership in inherited property. You're going to have to go through a process before you can actually force the sale of that property.
All right, Sean, thank you for the legal update. Reminder for the listener, today at 2 p.m. Arizona time, we have the Creative Finance Collective. What is that? That is a live show, an hour-long live show that we as attorneys in the space of creative finance get together and talk about all things creative finance. So if you as a listener are interested to learn or have questions about that strategy, the risks, the benefits, how lawyers see it, and how different states are approaching it from their own perspective and different set of laws, as we live in a country with 50 different sets of laws, maybe 51 if you add the federal law on top of that. But we get together with attorneys throughout the country to talk about that. We're on as long as you have questions. So it's important for you to engage and be there to ask those questions. We're there on YouTube, Facebook, and X. So be there, have your questions ready, and we're going to talk about creative finance. Also, if you have questions for today's show, we'll try to get to those in the final 15 minutes of today's episode. Make sure to just post those in the chat. You don't have to wait till the final 15 minutes. You can do it now. Post those questions in the chat. We'll get to those. We have somebody monitoring them, and we and our guests will address those. So today, we're talking about strategies in litigating real estate disputes. So as a real estate investor, what kind of litigation might you run into? What do these real estate disputes typically look like? Oftentimes they're very similar from state to state, though they have different names sometimes and different procedures. But with us to talk about that is a Texas attorney, a real estate litigation attorney, Tyler Epstein. Tyler, thanks so much for being with us.
Thank you guys. How are y'all?
We're doing well. So Tyler, I know you've been on the show, but some of our viewers may not be familiar with you. Give them a little bit of your background and what you do and how you got into doing what you're doing.
Fair enough. Nothing fancy about me. I'm overeducated roughneck from East Texas. So I grew up East Texas, where pretty much everybody became a lineman. Went to the logging woods or oil field. I went to college, graduated May of 08, went to the oil field because there were no jobs to be had. So my first job was picking up rocks. Boss man wanted to ask me if I was ready to quit yet because it's 110 degrees and I'd been picking up rocks for 2 days. And that was the only job I knew of I could get. So at 2008, so I was like, I'm fixing to put more of them back out so I have something to do tomorrow. And so anyway, went back to law school. Got into what I do kind of randomly to an extent, trying to make some extra money, and use my legal degree to understand how to find equity and extract it legally and fix problems, right? Like finding landlocked property and doing this, and that's really what got me started down that path. Since then, I have done multiple deals, have multiple partners. In fact, we're developing close to right at 2,000 acres right now across the different parcels across the state in different areas. So, you name it, I've done everything from easements and landlocked property, got local government officials in lawsuits for violating constitutional rights, airship issues, partitions, the whole nine when it comes to real estate. And I really like real estate because the law is well defined. Very well defined. We've got a 135 plus years of case law. So in reality, the only thing the players change, the facts are generally just the same flavor, or just a slightly nuanced flavor of the same thing over and over and over again. So if you read and study hard enough, you can have a very reliable, predictable outcome, as long as you know the facts perfectly, because facts matter. And sometimes people like to gloss over the facts they don't like, but I need to know all the facts. But as long as I know the facts, then I can pretty much tell you how the ball bounces, unless you're in a few select jurisdictions in Texas, and then I can tell you how the ball bounces there, irrelevant of the law, because it's a political matter. The law don't matter here. You're just going to lose because of certain characteristics.
So Tyler, you approach real estate from the litigation perspective, but also from the perspective of an individual investor as well. What came first, the chicken or the egg thing here? Did you start out as an investor or as an attorney looking at the opportunities that understanding the law would provide?
So I started out, long story short, I went back to law school because lawyers and CPAs run the world. And so I look around and realize that, I didn't really like accounting. So that seemed like a terrible idea. But honestly, I started out going into the law to apply it to my oil and gas background, because most attorneys have no idea what we do there. And then I ended up realizing that the law in the real estate thing, I could make money there without, with my legal education and the investor perspective. Because I bought my first duplex in 2009. So I was already investing, but very small level. And then it really took off after law school, because I was able to make a much better decisions and understand how to navigate some of the intricacies of development, and the law made more sense.
So we're going to dive into this a little bit more, but I think it's an important thing to note for the listener or the common real estate investor that doesn't maybe have the perspective of an attorney. You know, when they hear litigation, when they hear lawsuit, or when they even hear lawyer generally, they think of a fight, they think of a dispute, something that should be avoided at all costs, and maybe 99.9% of the time it is something that should be avoided at all costs. But there are strategic reasons that you've kind of implied or talked about generally, that with a knowledge of the law and how this might, and knowing how that the law works, that this can be advantageous, and that litigation is just kind of a process to uh, pursue, you know, certain rights that might be advantageous for you, the real estate investor. And we'll dive into some of
Well,
that, but go ahead.
it's a business decision, and it's not one to be taken lightly. And it really comes down to the rights, right? So property, you have the bundle of sticks, and I'm going to use my bundle of sticks, and it's never litigation and lawsuits in the court is never where you want to go. That's not the first decision. It's always a negotiation. Like, how do we work this out? How do we have a problem? Here's the problem. It's right there. It's obvious. Now let's fix it. What makes sense for us to do? And at a certain point, when you're obstinate, or you've got local government officials who just ignore the law for whatever reason, then you don't have a choice. You can either go Wild West on them and take the law into your own hands to fix it, or you have to go to the civil courtroom. Well, civil keeps you out of the criminal courtroom, so you go the civil route, and that's literally, it's to resolve disputes that generally can't be resolved, amicably between adults.
Now, Tyler, I think you just kind of gave a pretty good definition of where I was going next, which was kind of to define for the listener, what do we mean by litigation? What are we really talking about? And I think you really said it, but that it's really looking to the judicial system, the courts, to resolve the rights that, you use the term bundle of sticks. And for those of us who took property law, we're thinking about 1L property law class fondly. But yes, we have this bundle of rights when it comes to real estate. And when we talk about litigation, we're really just looking for the court to resolve those rights. Would there be anything else you'd add to that definition?
No, I mean, it's litigation. The term of this strategy, litigation strategy in real estate development. It's not a strategy. It is just, honestly, it's the last resort when nothing else works. You don't have a choice, because you either have a non-marketable property that can't be financed with equity, that can't be unlocked and into perpetuity, or you go to the court system to fix it. If you have a leaky faucet, you hire a plumber. If you have a problem with, that you need to fix, you have to go to courts to have them fix it. That's their job.
So, Tyler, we want to talk about specific types of litigation or actions within the courts that are real estate specific, that a real estate investor, if you do it long enough, is going to run into either by plan or be dragged into,
Always plan.
Yeah.
Always plan, because you're going to go there. So you need to start planning now. Because the first time you get sued is not fun. And the second time, it's not even better. And the fourth or fifth or sixth time, you get more comfortable with it. You get more comfortable with the courtroom. You get more comfortable with the process. It's never fun. It's emotionally damaging. And it's a time suck. And the trial courts are never, it should be mostly cut and dried. But as we talked about earlier, judges sometimes just want to be what they consider fair, and they're activist judges, or maybe you're being hometown and the party that you're going against is the banker or the mayor, or the beer drinking buddy with the banker or the mayor in town, and you're fixing to get every ruling against you, and you can't do anything about it, but it just cost you $100,000, and you're going to the appellate court now, who is going to take you 2 years. You may spend the next half a decade and not have any resolution, but you've been spending money the entire time.
So we have a number of specific types of actions we want to talk about, but before we get into those, sometimes the best way to take the temperature of a market and where a market's at is just to ask What kind of actions are you seeing right now? What kind of actions do you seem to be doing the most? Why don't we start there? What type of real estate actions are taking up the majority of your time right now?
Most everything that's taking the majority of my time right now is local governments. We're developing property, and or people are developing property, and the locals don't like it. Oh, these people they ain't from around here, and they're bringing these outsiders into our community, and they're taking our jobs. So anyway, they want to prevent growth because people hate change. And I always call it Frankenstein syndrome, right? Frankenstein was killed because he looked different. Oh, he looks different. Got to kill him. And that was really a story about humans, right? We don't like change. We don't like people that are different from us. So got to kill it. Well, the same thing goes. You got local governments. They've been in power. Generally, they're from there or been there a long time. They have some money. Their family has all the clout, or their inner circle, and they're more than happy to let them develop property and make money. They just don't want them outsiders doing the same thing. That's our money to be made. That's Jimbo. He's the banker. He makes that. He does that. Don't let that outsider come in here and do that. And so they make it difficult. Well, when they start doing that, generally they violate the laws because very few people are willing to go toe to toe with them, to go to court or argue against them, because they've been bullies a lot, and they've gotten used to being a bully. They've gotten used to getting their way. And so they're not used to having somebody stand up and fight back. There's also the Constitution, federal court, 42 USC 1983, which is civil rights, which are really hard to enforce against a government because of all the immunities. But you have to be prepared to take it all the way, because if we can't make our government officials and the local authorities follow the law as written, what's the point of having the law? And I say this, that with the immunities, the local government can go, oops, I made a mistake. No harm, no foul. They go on about their life. Us on the other side, as investors or developers or just people in general, we have to be absolutely perfect. If we make a mistake, they can send us to jail for doing certain things in the development world. Just by making a pure mistake, you go to jail. There was no intent to violate the law. Well, it says here, and now you're in jail. So we have to be perfect. They get to make a mistake, and oopsie. It's like, that spilled the milk. Boo-hoo. That's not okay. The cards are already stacked against anybody in development. And so, what I'm seeing is having to be perfect, having to know the law better than the government, and then having to make them follow the law.
Well, I think that's pretty interesting. It leads me to a question. I've run into this in this state. I'm curious if it's the same way there. But one of the things you said there at the end, which is to make them follow the law. I've seen local municipalities have a law that's passed, have developers say, okay, within the rights of this law, this is what we want to do. And then there's, of course, like you said, public pressure. The public doesn't like it because it was never this way, or we just don't like it, right? And we're going to vote you out if you don't do it. And they basically decide to either undo the law or try to undo something. But what you've had at that point is you've had developers, you've had property owners rely on the law that was in place, make investment decisions in buying property, and now you've then you've flipped it. Now they don't have these rights. You've changed the zoning laws or something to that effect. Now here in Arizona, if you impair, or kind of go backwards in terms of rights, in terms of a landowner, that can be considered taking, and they can be obligated to compensate you. Is there like a constitutional requirement in Texas for municipalities that undo favorable laws?
Yes, and it's a constitutional, United States Constitution issue as well. Yeah. And the law is very commingled and terrible. It's sorting through it is a rough process. It's terrible because the cases are bastardized a lot of times by bad lawyers and bad arguments, which create bad case law, or you will see the appellate courts using what I call mental gymnastics to come up with the outcome that they wanted to see instead of the one that should have been brought. So they'll do mental gymnastics to try to contort into the outcome they wanted to see. Which is what Clarence Thomas fights at all the time, is like, we just got to follow the rules. And to your point, my biggest thing is as a person in the world, every person should be able to read the law and rely on it to a T. As long as I follow, I call it Betty Crocker law. I want to bake the brownies. How do you bake the brownies? Well, you get the box of Betty Crocker out, you mix the eggs with the butter, you preheat the oven to 350, you put it in for 30 minutes, bang, brownies come out. It's amazing. But all of a sudden they change the rules on you, and then the next thing you know, you're like, I burnt the brownies. I didn't burn the brownies. I did exactly what it said on the box. Oh, well, we changed that rules. That's not fair. That's not justice. Like, there's a reason, without having that kind of standardized process, the rules get changed on you, and you're just supposed to take it. I don't comply with that, right? I don't bend the knee and be like, oopsie, I guess you made a mistake and you don't like the law you wrote, so now it's my fault and it's my price to pay. If the public is going to get a benefit at my expense, the public should pay me for that. So if you want to turn my property into a park, then buy it and make it a park. I'll make you a hell of a deal, but you don't get to take it from me and make me suffer for the good of the whole. And that's the takings clause, and the Fifth Amendment that we fight, as well as equal protection and due process. Because before the law can be changed, you have to notify me and tell me it's going to be changed. Let me make my presentation of why it's not fair. Without that, there's really no reason that we don't strap on our 6-shooters, walk out in the street, handle business, and go back about our lives, right? And I say that to be dramatic, but without the civil laws and without being able to follow them, why do we have them? What's the point of me following any of these rules if we're just going to change them?
Sure. Well, it sounds like, given that you're doing a lot of disputes with zoning, rezoning, or municipalities, it sounds like development is pretty aggressive out there in Texas.
Oh, it's huge. I mean, I don't know if you pay attention to the news, but we have an open border, which to be honest, I have no problems with it to a large degree. I mean, I don't like it, but at the same time, yes, are bad people coming over? Absolutely. There's bad people living here already. There's going to be bad people. We're not going to fix that. But a lot of the people coming over here are great. And it's one of those things that, like, I wish them the best. I love them with all my heart. They went through trials and tribulations that most people will never understand. And I'm not going to, I watch people all day break laws and not get persecuted for it. I'm not fixing to persecute them for that. But we have a whole lot of people moving here, both legally and illegally, from across the country. We have fairly decent business regulations that are getting fixed more and more in the legislature to take power away from the local despot governments and the ones that abuse their powers. And that's going to happen again in 2025. I've already seen the writing on the wall. So, I mean, I want to say in the last 7 years, we've had more Fortune 100 companies move to the state of Texas than anywhere else. Like, to the tune of, I think, over 25% of the Fortune 100 companies have their headquarters here now. And we haven't even touched the northeast half of the state, or quarter of the state is largely undeveloped with a workforce out of this world. So I actually see more development coming here because we have plenty of workers that can do the physical labor. We have an environment that is advantageous to building a business and manufacturing facility. We have the largest ports. We have the most transportation. It's a melting pot. And so I actually think it's going to get better over the next decade. And, the Texas that I grew up in is going to change. Well, nothing stays the same. So, I've accepted the fact that you can either help guide and direct it, but you can't stop it. And trying to stop it is how you get run over.
They've moved your cheese, Tyler.
Yes.
It's gone.
Oh, it's gone. It's one of those things that it's not the same community, but at the same time, I think it's better. It's different, but it doesn't make it bad.
So talk to us. Let's move into some specific types of actions, because the real estate investor needs to know what the toolkit looks like, and and begin planning for these eventualities. Talk to us about the specific performance action. What is that? And what should are you seeing those very often now? And what should the real estate investor be thinking about when it
Well,
comes to something like that?
specific performance, but before we get into this, I want to clarify one thing, that these are all tools in the tool belt. Hiring an attorney to do this for you, they don't just assume all of your knowledge, and they can't fix all of your mistakes. So you need to have a process and document everything and do everything perfect. If you want the right outcome in court and you don't want to have the baby split, proverbial baby, have it split by the judge, be perfect. Don't lie, don't cheat, don't steal, do follow the rules, make the brownies. Know how to make the brownies, and then make the brownies perfectly. And litigation is by no means a threat. It's not a scare tactic. It's not used to abuse people. It's not a system to take advantage. It is a system to fix a dispute, and not to take advantage of grandma who you lied to and got in a contract with, and now all of a sudden you put a memo on her property 2 years ago, and now you think you get $15,000 because you lied to grandma then, and no, that's not okay. You make my skin crawl. So to that extent, do the right things. Now, after my PSA on that, we will go to specific performance. So I'll look at it like this. I've had to use it a couple times, not personally, but for clients, where they negotiated a deal. One of them was a big commercial project, right? And so they wanted to buy it, and they negotiated a price and got the price. Well, all of a sudden it came down to closing. Guys like, nah, not doing it. Don't want to. Change the terms. Give me another $100,000. No. Well, you have two options. You can not buy the property, or you can sue him for specific performance. Say, here's the terms of our agreement, Your Honor. Enforce them. He's not honoring his agreement. I want them to be honored. I want the property, and I'm willing to pay X. And that's it. Now, with that being said, your contract needs to be either a sophisticated contract drafted by an attorney, or we have the Texas Real Estate Commission, a TREC form is what I call it, so that the judge knows what it is. If it's a 2-pager that looks like it was written terribly by a third grader, the judge is most likely not going to enforce that, because it's probably not enforceable, but they're not going to like it because there's no law around it. The TREC form, there is a lot of law around the different provisions in the TREC form, because it's been around so long that the judge has comfort making decisions. Same thing goes for sophisticated contracts. They're most likely a flavor of the TREC form and have maybe more specifics, but also have the same baseline basis around it. So now you can go, Your Honor, I want to enforce clause 9, the specific performance clause, or clause 17, because see case A, B, C, D, where this has been done before. So we're just making the brownies, Your Honor. Look, the brownies have been made. We tried to make the brownies. We just want to make the brownies. And now the trial court judge goes, well, my hand's tied. I got to follow the law. Bye. And as long as you have a good contract that follows something the judge has seen before, you're not Frankenstein. He's not going to kill you. He's going to make the brownies with you, and you're going to get your property ball.
Yeah, I think
here in Arizona.
Go ahead, Sean.
Yeah, so here in Arizona, and I'm assuming it's similar in Texas, a specific performance action, assuming that the seller shows up and answers the lawsuit, it's going to take some time to, make its way through the system and actually have a judgment. What stops the seller from finding another buyer and selling the property to another buyer while that lawsuit's, going forward?
You've got to file a lis pendens, and the only way you can file a lis pendens without it being an improper and getting potentially some healthy sanctions and fines about it is you immediately file a lawsuit and a lis pendens stating the cause of action, the case number that was assigned to you by the court system immediately. And so that stops it and makes them come to the table right there. And A lis pendens is not something to be taken lightly. Same thing for me with memos. Memos are not to be taken lightly. You have to do them properly. Have I done it before? Yes. Was it proper? Absolutely. I followed it to a T. But you have to file a lis pendens. But if you do a lis pendens cannot be filed without a lawsuit being pending. First, and then two, if you have an improper lawsuit, especially when most of these things, if you're dealing with a $10,000 house, the juice isn't worth the squeeze. So most of the time when you're dealing with specific performance and a lis pendens, you're dealing with $100,000 plus at a minimum, most likely. The party on the other side can potentially hit you and will hit you with counterclaims of statutory fraud, fraud in a real estate transaction, and all these other claims. And now you're in it to win it. As you said, it's going to take a while to grind through. I'm not one, I don't practice that way. So if I have a case, I tee it up for motion for summary judgment immediately. The rules of civil procedure allow us to file a motion for summary judgment immediately upon being served with a lawsuit or when they answer. So you serve them with a lawsuit, they got 20 days to respond. They file their general denial. I hit them with a motion for summary judgment or a partial motion for summary judgment immediately. Because as a real estate investor, your paperwork should be clear. Your email communications, your text messages, all that stuff with the title company, et cetera, all should be very clear, very clean, so that I can file a motion for summary judgment, set it for a hearing in 3 weeks, 4 weeks, and we just hit the go fast button. They don't have time to delay and drag it out. They're having to respond to a bullet, first contact immediately before they've had time to manipulate the situation. And the attorney on the other side is generally, hey, Mr. Attorney, I got sued. You get the file. You're like, okay, send me discovery. I'm going to file a general denial. You wait until the 21st day. You send, I deny everything in, and you're sitting in there. You're sitting on your laurels. You're like, I've got time. We're going to get discovery. All of a sudden you show up. You're like, motion for summary judgment. This asshole, and now you're having to call your client and be like, send me everything because I'm having to respond to this right now. Well, it helps refine the entire case for the judge moving forward. It's expensive. So a good motion for summary judgment, as you know, is a $13,000 to $15,000 document, but it helps speed the process up and refine the arguments quickly.
Now, in a specific performance action that presumes that the parties had a contract to purchase, in Texas, will the court award the prevailing party attorney's fees?
On a contract, you should, because almost every contract TREC has the prevailing party gets attorney's fees. On a contract dispute, prevailing party gets attorney's fees by statute. I forget which one, but contract disputes do get attorney's fees. It's generally plaintiffs' suits for your torturous, assaults and slip and falls and stuff like that you don't necessarily get attorney's fees.
All right. Talk to us about the quiet. Go ahead, Sean.
So on commercial transactions, it's pretty simple, right? If you're awarded attorney's fees, you're going to take them out of the seller's proceeds of closing, presumably. You just garnish the escrow agent. What about if you ever have to pursue specific performance on residential real estate that may be considered homestead? Can you take the sales proceeds out of, or take the judgment out of the seller's proceeds?
So that's a good question that I don't have a good answer to. And I say that because it depends. Because in Texas, you don't get homestead. Now, if you're over specific forms of the homestead, I'm inclined to say that you would be able to get attorney's fees over that, because essentially, but like say you were buying the vacant land and you were suing them over their vacant land, and then the only asset they had was the homestead. No, you couldn't get that out of that. But you could potentially reduce your purchase price down by your attorney's fees to recover that. On the offset that the client or the opposing party does have other assets and you want to get them, I personally am a big fan of receivers. You have the court appoint a receiver to enforce the judgment. The receiver collects his attorney's fees and generally 25% of the judgment award. So, but he doesn't get it from the plaintiff's award. It's on top of. So if I want $1 million and I get a receiver appointed, he collects his $350 to $500 an hour for enforcing the judgment, and then 1.25 million is because he goes after it, and so it's a strong thumb on the part of, you need to figure out how to get out of the pickle you're in, because it's just going to cost you a 25% coupon on top of what you've already lost. So receivers have an ability to miraculously find people willing to negotiate.
Talk to us about the quiet title action. How do you utilize that, or how do you see real estate, or how do you utilize that for real estate investors? What do those cases look like?
In Texas, and this is one that's very fact specific in Texas, because we have two causes of action for real estate matters. We have quiet title and trespass to try title, and a suit to quiet title. And I look at both of them every time this matter comes up, because it's so fact specific on which one you can file and which one you get attorney's fees for, and what, and how you potentially bring that cause of action. And so I don't quote me on this, because I literally do every time I go pull up the two statutory cases and read them, because the Supreme Court has even refined it the last 3 or 4 years again, right? Because it's not one of those things that it's just kind of muddled. But a quiet title action is like the strength of your title. I have a title of the property. They have a title of the property. Who has a stronger title to the property? Meaning, my line goes back to Stephen F. Austin, the father of Texas. So I can track my title through the deed records all the way back to Stephen F. Austin. My title's stronger, and then his title comes from Stephen F. Austin's nephew. Well, I don't, so that's kind of what a quiet title is. Who has a stronger title? The other one is trespass to try title, which is kind of like, I don't care who has title to the property. I have a stronger right to the property. I've been paying taxes on the property. I've used the property. It's kind of an adverse possession light. Because adverse possession, everybody always loves to throw out, well, I'll just file an adverse possession claim. It's not 1860, Hot Rod. That's not how that works. That's a disfavored law. It was for the Wild West, when people didn't have access to surveyors and didn't have all this access. And and courts, in the Supreme Court of Texas, I want to say in around 1980, actually said, we frown on adverse possession. Now, they still deal with it, right? But it's not a sword. It's more or less like, you ain't taking Aunt May's house because you own your daddy owned it since 1950. You haven't paid taxes on it. She's been living there since 1950, paying taxes under what she assumed was title. She just didn't file it, or her grandmother didn't file it. You don't get to now come back and take it from her. She has a good adverse possession claim. You can't claim it because you have better title. That's kind of what adverse possession is for the rare nuanced cases. Because as our first conversation, the law is written, they want to rely on documents. They want to rely on the rules. They just want to make the brownies. They don't want this wild card of adverse possession changing the name of the game for the players, right? You should be able to rely on your document.
Now, in the adverse possession situation, comparing that to like the specific performance, now we're not talking about a contract. This is, like you said, a competition of
it's a
folks claim the
right.
title. Yeah.
It's a claim of right? And there's different levels of there's a 3, 5, 10, 15, and 20 and 25. Maybe I forget for adverse possession. It's not something that I really ever recommend, except for one time in my career. I literally had a case where the lady had been living there. It was her grandmother's house. I'm assuming it was sold to her sometime in the 70s. And because that's how long that you could see that she'd been paying the taxes on it. And then this family, grandpa died. They find out that they have title to it, and they're like, we're evicting her. No, you're not fixing to kick out somebody that's been living in a house 55 years paying taxes. I'm not, that's not okay. And so we straight up were like, here's adverse possession. You're going to grant this and we're going to give you $1,000, to go away. And I'm going to do all the paperwork for this lady, but you're not fixing to take her house, you know? And they hired an attorney and he you don't understand it. I'm like, nah, I'm good with this one. Like, this is clear cut adverse possession. This is a lost type. This is a lost document kind of thing. These aren't squatters that moved into the house and just try to take it. She legitimately has a claim of right to that property. You didn't kick her out for 50 years. That's not you settle on your rights. You don't get them back.
Now, in quiet title actions, so I'll just say in Arizona, for instance, bringing back up the attorney's fees question. I keep bringing it back, the attorney's fees question, because an investor is going to want to know, what are my chances of recouping whatever I spend to do this? They're going to have to bake that into the calculation as to whether this is worth the time to do. In Arizona, you can be entitled to an award of attorney's fees in a quiet title action, so long as you follow a certain prescribed procedure, putting the other side on notice, giving them a chance to correct it by quick claim deed and some other things. Is there a scenario where you're a party bringing a quiet title action, whether it be by adverse possession or some other form of quiet title, that they could recover their attorney's fees, or are those just all in and just expect to pay and that you're going to have to eat it?
Generally, no. And there may be a very narrow sense where you can file a deck action. And this goes back to the trespass to try title and the quiet title nuances in Texas. And the reason I'm not willing to go into it too hard is it's so fact specific that on this podcast, it would be too detailed of information to be able to be even ingested and reasonably have an idea of what you're talking about. But yes, there is a very narrow stance, but because the courts, and this case law stuff that the courts have created, it's generally no, you're not going to get attorney's fees is the quick answer.
Now you mentioned their declaratory judgments. Now, declaratory or seeking declaratory relief, I think, is something that as real estate attorneys, we see more often than a lot of other attorneys see. Why don't you explain for the audience, break down what we mean by declaratory relief or a judgment as opposed to like what you would typically see, which is a request for like monetary relief.
A deck action is essentially says this document says this, judge, tell the opposing party this document says this and it means this. That's the simple answer what a deck action is. It's declare the words on the paper mean what the words on the paper mean. That's the easy answer. And it can be over a contract, it can be over a deed, it can be over the law, right? I've had to file a lawsuit against the county government officials, ultra vires, which means they're against the law, and it's a deck action saying that tell them the law says that I'm right. Like and the law actually applies to the government too, because the last time that somebody thought the law didn't apply to them, we asked them to politely go back to England, and that's kind of how this works. And so that's what that amounts to.
Now, you mentioned in your prior real estate experience and probably current experience, you were into multifamily. You may still be into multifamily, but you're not in multifamily and not knowing what eviction is and how eviction works. I imagine that's a pretty important procedure to understand if you're a real estate investor, short-term or long-term.
It is, and the best answer is if you're knowing besides having a process on how to handle and document the eviction process, you should never handle your own evictions. It's a terrible idea. It's cheap, easy work for an attorney. Find a good eviction attorney. There are several people out there that don't want the stress of massive litigation because litigation is terrible. It's stressful, it's long, it's cumbersome, it's expensive, but you can have a eviction docket for multiple investors and you can evict people. And it's pretty easy. It's pretty straightforward. It's a cookie cutter process. They make the brownies every day. Pay them their $1,200. Give that man his money. Here's the documents. Evict person. Go on about your life. Because if you're trying to do this yourself, A, there should be a higher and better use for your time. And B, the odds of you messing it up or the judge just not liking you is high. They don't like pro se. Judges hate pro ses, which means you're representing yourself. I don't care how smart you are. Want to get poured out of court? Represent yourself. You want to know how I know? I represented myself as an attorney in a case. The judge was so pissed off at me, so mad. I had to go hire somebody. So, lesson learned.
Well, and I think what's interesting in the eviction process, you can confirm whether it's the same in Texas. I suspect that it is. But to your point, they're designed to be quick, fast, and if you follow the rules, you get what you want. You get it relatively quickly. But the big provision there is if you follow the rules. What I've found here in Arizona, you will get everything that you want. But man, if you just slightly get that notice wrong,
you can't stub your toe.
Yeah,
you can't. There are no. It goes back to the comment I made at the beginning. You have to be perfect. The government can make mistakes. You can't. You can't. At the same time, depending on which jurisdiction you're in, matters. You're in a good jurisdiction where they uphold the law as written, you're good. You're in a jurisdiction where a bunch of political animals and the political party that is in control of the government there leans a different way. I don't care how right you are. You're not going to get your eviction in a timely manner. They're going to give the other party multiple opportunities to stay. Like during COVID, I had a lady squat for 9 months. And I'm sitting there clicking off $1,900 a month payments and electricity bills, because guess what? She wasn't paying that either. So I finally just told electricity to shut it off. Well, somebody's living in there, not legally. So, we got rid of power in August and she left. It was hot. It was nasty.
Yeah, I like what you said, though, that the landlord should expect to be basically perfect. If you're perfect,
no, you have to be. I mean, even in good jurisdictions, a good judge, and I always prefer good judges. If you violate somebody's rights, those are their rights. Those are their property rights. And I say that those are those due process rights. And as the lawyers, the Constitution gives them that right. And it's our job to make sure that they get it. And so if you stub your toe, you have violated their constitutional rights. And by all means, the judge should let them stay. And, that may seem different when you're an investor. Yet that doesn't mean you get to violate somebody's rights because you're an investor. You're no different than the local government not following the law. You have to follow the law.
So one final action I wanted to talk with you about as we kind of approach the end here is what Sean talked about in his legal update, the partition action. Do you see a lot of partition actions? Do you like to use that as a strategy for investors or for yourself?
It's not a strategy that I use now. It's one of those things I have done them, and I'm working through one right now, and I've got a terrible ad litem who didn't follow the judge's order of trying to locate these people. So long story short, there's titles, all crazy chaos back when people would just, go get a state promulgated form and they could steal a notary stamp and forge deeds. And this lady that got the property to three-fifths of the property was convicted of forgery, so the title's terrible. And so now I'm having to try to clean up title, and and you get a bad ad litem who doesn't want to do the hard work, which is trying to find some people. So they just file a defense action, which is not their job. I don't pay for their civil defense unless you can't find them. If you can find them, they get to hire their own attorney, not on my pocketbook. But yes, partitions. There is an air statute in Texas. It was passed, I think, in 2019. You can Google it, research it. It was started, and it's not a terrible thing. I understand the reasons behind it, but a lot of times the way that these properties come across my desk are nobody's paying the property taxes and hadn't for a long time. And the local jurisdiction for 20 years kind of knew the family, knew their financial situation, so they didn't up their taxes. And then now all of a sudden that property went from being $1,000 an acre for 5 acres to $15,000 and the taxes are like, we want our tax money. So they run the taxes up real high, and you can get, like you said, 3 or 4 of them, and one of them still living in the house without power and rigmarole. It's a kind of a terrible situation. You know, I've been involved in this where I was involved in one of these, and we tried to buy the lady a house about 20 minutes away and give her her own house 20 minutes away to get out of this particular property. This is my grandma's house, but grandma paid her taxes. You didn't. Like you don't get to live in a house for free without paying taxes. Like, now I don't like taxes either, but just because I don't like them doesn't mean I don't have to pay them. You don't have to like the law, you still have to follow it. So, you know, we have used it, but you need to do everything right. You need to document everything. You need to be on the up and up, and it needs to be clean, because property is sacred in Texas. The Supreme Court takes property rights as sacred, and violating somebody's property rights, I don't care if it was, it's not a good idea. It really isn't. Now that's not to say that sometimes it happens, but you shouldn't on the first pass. You should make sure that you do your best, and it needs to be clean. Like I said, you need to do the right thing.
Tyler, one final question. I know, because you see a lot of litigation and have throughout your career and been a real estate investor yourself, what is the biggest mistake that you see real estate investors make as they prepare for litigation? Or maybe as they're entering litigation and they don't even know they're entering it yet. But what is the biggest mistake you see them make? Sloppy.
And I say that they listen to somebody on the internet. Well, somebody said I could do this. Well, that's a terrible idea, because you didn't go read the law, and they're in X jurisdiction and you're in Y jurisdiction, and that's not how it works here. And, well, that's my money. Not anymore. It's their money. You fixed a house that you didn't own, so you made a gift to them. Good luck. You know, you don't. You know, it's a terrible situation. Or a lot of times they use a 2-page contract. Well, now you just, you know, you're asking me to take something that looks cheesy to a judge who's going to think that it smells funny because it looks like cheese and it smells like cheese and he doesn't like it, to agree with you that you're not taking advantage of somebody when you absolutely did. So I'm not taking you as a client because I don't like you as a person. I don't think your moral compass is very strong. And so that's the first issue. The second issue is learn the law. 3, document everything and know the facts on how to navigate. And 4, like, just because you can doesn't mean you should. And I say that just because you can buy a subject to doesn't mean you should buy a subject to. And just because you can lock up a property, but you don't have the ability to pay for it, doesn't mean you should. Like, I just came across, so I've been negotiating with a broker on almost 500 acres for the last 60 days. They wanted $4,700. They wanted $6,500 an acre. I got them down to 5, and I wanted $4,750. That was my no-go, and I was working on it. Well, investor came in and put up like $150,000 non-refundable earnest money to lock this property up for 4 months, and they're going to try to owner finance the lots out and then have everything and have a simultaneously closing. And so you have just created a pile of coat hangers, of legal coat hangers, that you don't even understand how, if that house of cards wobbles and when it collapses, you have a sophisticated seller who could potentially sue you. You're going to have 10 other parties that have money involved, an equitable right to the property involved, with down payments involved, the specific performance suit potentially involved. And I'm like, oh my God. You know, at the end of the day, there's going to be a DA involved, which is the thing. Don't be sloppy. If you're going to do this, like there's creative, like their creative finance, you can be creative, but you need to be perfect. And that requires a lot of administrative work that a lot of fly-by-night guys or people that play fast and loose with the rules, sometimes because they're playing fast and loose, and sometimes because they just don't know any better. They're not educated on it. They're going to wind up in bad situations.
All right, Tyler. Well, we really appreciate your time. Good information. Tell our listeners how they can connect with you.
Easiest way is Facebook. I think I have a Twitter or X profile. I don't even know my handle. I use it to look at it. I don't advertise a lot on it. But find me on Facebook and message me. I will say that I am an attorney. I'm not your attorney. I do practice law for select clients. I will help you any way I can. Sometimes I'll charge. Sometimes I won't. A lot of times I am employed as a legal consultant. So meaning straight up, I'm not there necessarily an attorney, but I give them advice and work through things and answer questions for them and help their counsel or help them find outside counsel that can handle their matter. Because just like me, I'm a real estate attorney. That doesn't mean I handle all real estate. Like eminent domain, I know enough about it that I'm competent. I'm not the guy I can negotiate with the state on your behalf to settle it. But if you go to trial on it, that's a whole nother let of rules and processes and procedures that you need to hire somebody that marinates in it, just like family law. I ain't representing you for your divorce. That's an emotional trauma that I would like to not have. And you can't pay me enough to take your emotional trauma on. So that's it. But yeah, Facebook, Tyler Epstein, not hard to find. And don't ask me a question you don't want to answer to, because it's not really what, I'm going to give you my opinion, whether you fancy it or not.
All right. Well, this has been awesome, Tyler. Let's do it again soon.
Yes, sir. I appreciate it. Thank you, guys.
All right. You have a good one. With that, everybody, that is our show. Make sure to join us at 2 p.m. for The Collective. We'll see you next week.
Have a good day, everyone.